Indira Jaising is not just a senior advocate. She is the reason why we question how seniority is earned. A crusader for transparency in senior designations, and the first woman to be designated as a senior from the Bombay High Court. She has been pursuing this cause of senior designations relentlessly. She has perhaps shaped this entire debate which the Jitendra Kalla judgment delivered by the Honorable Supreme Court in the last 1 week now reignites. There is perhaps no one more relevant to this conversation and to this moment than Senior Advocate Jaising. Thank you, ma'am, for being with us.
Pleasure.
The recent judgment critiques the interview component of the designation process. Could you clarify your original stance on the interview component in the senior designation process as a mode to evaluate candidates, and what alternative methods would you suggest?
So before I answer your question, I'd like to go back to the original inspiration for filing it. As you know, it was a judgment delivered by 3 judges, and by that time, I had observed that designations are made in a very elitist manner. I would notice that only those who are very close to the judges, either as sons or daughters, or who have access to the judiciary, would get designated, and others were not getting designated. This is what motivated me to file it. Moreover, I must tell you, and I'm sure you're aware of it, that the system has changed worldwide, more particularly in the UK, from where we seem to have borrowed the system of senior counsel under Section 16 of the Advocates Act. And my hope and my desire was that there should be transparency in the way in which people are designated, the why of it, why designate someone. So the big question really is, do we really need this distinction between designated and non-designated lawyers? And if the answer is yes, then there has to be something about a person who is designated which is different from a person who is not designated. And I would say for that it is issues like the ability of the lawyer to maintain a certain ethical conduct, the ability to rise above the brief in question, excellence in knowledge of law, ability to actually tell a judge objectively what the law is. I also believe that lawyers should cite judgments which are against them. You do not indulge in sharp practices, but most importantly, equality of opportunity. This is why it was filed. Now I can answer your question about the interview. Generally speaking, I do not believe in the ability of an interview to tell you anything about a person. And normally interview marks are used, from my understanding and from my knowledge and my experience of having worked extensively on service law and labor law. I had noticed that the component of interview is often used to kick up or kick down someone. Okay. And that is the reason why in my original suggestions which I had made to the court, there was no component for an interview. So when the judgment was delivered, Justice Gogoi did announce in open court that he had put 25 marks for interview, and I did get a bit of a shock because 25 out of 100 is a bit too much for an interview and leaves enough ground to manipulate. You know, if you want, you can, a person who doesn't make the grade in terms of years of service, in terms of the nature of judgments, can get a 25% addition to kick the person up. And so I did draw the attention of Justice Gogoi to this, that where did this interview component come from? To which his only answer was, the judgment has been delivered, no further discussion will be entertained. So that's as far as the interview is concerned.
Did any lawyer specifically argue the interview component during the hearing and seek a 25% allocation for the same?
Not at all, not at all. So having said that, I would say that it would be reasonable if any 100-point in-text wanted to have an interview component. However, 25 marks is far, far, far too much for that, even if you do want an interview. First of all, the interview should have substance. So this time when I was arguing the matter before a bench presided over by Justice Oka, he put the same question to me, what's the purpose of an interview? So I said, well, if you wish, as the interviewing judge, you should ask the questions of lawyers which are academic in nature, which are creative in nature. For example, you take acts like the POCSO Act, where the burden of proof is reversed. And if I was sitting for an interview and interviewing somebody, I would ask a question like this, well, oh, Mr. Counsel, Miss Counsel, what have you to say about the reversal of burden of proof in a law like POCSO? Do you or do you not think that it goes against the basic principle of presumption of innocence? And if there should be an exception, on what grounds? Now that's when you're able to test the creativity of a lawyer, that this is what is expected at an interview. But I have been told by people who have been called for interviews that no such intense interaction happens between the selection committee and the candidate.
But so do you think that the interview component left an element of judicial bias into the process?
Yes, I have no doubt about it, but I'm not able to substantiate it because the mark sheets are not published. They're not in the public domain. But the very fact that you put such a large component for interview allows any kind of manipulation. So I would say even if interviews are to be retained, the number of marks assigned for interviews should be reduced.
Ma'am, the court in this judgment by Justice A.S. Oka-led bench has said that lawyers must possess subjective qualities like ability and standing at the bar. My question to you is, for designation, how can these criteria be quantified?
So, with great respect, I feel that the bench presided by Justice Oka has simply not understood this issue. While agreeing with everything that he says in terms of what is expected of a lawyer, you hit the nail on the head by saying, how do you quantify it? Now, what I want to tell you is that worldwide, and certainly in India, whenever there is a selection process, the desirable qualities are always quantified in terms of marks. You take any selection process. Let's begin with the Indian Administrative Services. How do you decide who makes the cut and who doesn't make the cut? So you have your set of questions or knowledge required, and then you have the marking system. What is a marking system? It basically allows you to quantify a criteria that you're looking for in order to decide whether on the totality you make the grade or don't make the grade. So you take anything, you take the Indian Administrative Services, you take entrance examinations to law colleges, you take entrance examination to medical colleges. Everywhere you go, you have a marking system. Why? Because it's a selection process. So no matter what criteria you use, ultimately those criteria have to be quantified. And the only way you can quantify them is through a marking system.
Which brings us to the next question. With the Supreme Court having done away with the marking system, what other objective criteria can be used to determine the suitability of a candidate for senior designation?
I'm sorry, but this judgment is not the last word on the subject. So I do not wish to discuss this on the assumption that this is how designations are going to be made in the future. There is going to be a prolonged legal process before we arrive at what should be the process. And Justice Oka himself has said, put a moratorium on all designations for the time being until guidelines are laid down. So A, we need to wait and see what those guidelines are. But apart from that, I would like to say that this bench of 3 judges has undermined the basis of the judgment of a coordinate bench of 3 judges. I believe that the bench had no jurisdiction to do what it did. And I believe that if the bench did want to undermine the basic structure, the substratum of the judgment, they had a duty to refer it to the Chief Justice for a reference to a larger bench. So the question you asked is capable of multiple answers. Number one, we wait and see how high courts are going to do this. Number two, will there be a review petition? Number three, will there be a curative petition? Number four, will there be a petition under Article 32 challenging the constitutional validity of Section 16 as being completely arbitrary, unguided discretion? Right. I believe that this judgment has taken us 10 steps backward, back to a regime where it's going to be what we used to call face law and not case law.
So do you think the judgment should be set aside?
I certainly do. The question of, however, is what is the process and also what will replace it.
Ms. Jaising, will you be filing for a review?
I am contemplating my options, but I can tell you this much, that if you have an opportunity to read my original petition, you will find that the basis of that petition was equality of opportunity and equality before law. I'm proud to say that after the judgment, the doors have been opened to designation. I'm also proud to say that a huge number of people, both men and women, have been designated. And I'm aware of this argument that, oh, you know, not everybody who's designated has the necessary qualifications. Well, I would like to ask the question, how many people who were designated before the Indira Jaising 1 judgment had the necessary qualifications? Yes, they did have the qualifications of being kith and kin of judges. They did have the qualifications of being high net worth individuals. But did they have the qualifications of being worthy lawyers? That's a question to be asked in relation to the pre-Indira Jaising 1 judgment. And I feel that it is my duty to introduce a democratic system of functioning at my workplace. And my workplace is the courts, whether it's the High Court or the Supreme Court of India. And I saw what I did as the process of democratization of the bar. And I think the purpose was achieved, notwithstanding the fact that large number of lawyers were getting designated. One thing, of course, I would like to say, we have seen people being designated who have had a track record of indulging in sharp practices. I believe Rishi Malhotra is the person against whom these allegations have been made of sharp practices. I certainly would like to ask the question, which court designated him? It was this very full court, okay? Can they answer to the question, how did you designate somebody? Why put the blame on the system of designation? The judges also need to look a little inward and decide for themselves, where did they go wrong?
You know, this brings me to a very important question. Do you think this entire Rishi Malhotra saga had a casting shadow sort of an effect on this particular judgment being delivered? Do you think it kind of influenced the judges so as to say, beyond the arguments, to deliver something that you put it as that, which takes us 10 steps backward? Do you think that episode had something to do with it?
I have no doubt in my mind about it. And the fact of the matter is, even today, judges are willing to tolerate sharp practices at the bar. Why? Why was somebody, this is not about Rishi Malhotra, it's about ethical practices or unethical practices at the bar. They're tolerated. Why? There is a duty cast on the judges also to ensure that the legal profession functions according to certain norms, according to certain rules of conduct. And when you allow those standards to get eroded, I blame the judiciary more than the legal profession. Of course, the legal profession must self-regulate.
So, was this a tragedy of generalization? Like the Yashwant Verma controversy cannot, of course, cast a shadow on the doubt that all judges in the residences have, cash stacked. Of course, it's an allegation as of now. But should the Rishi Malhotra episode also come to be generalized in a fashion that such a judgment has been delivered, according to you?
See, I don't think it's that. I think it's the numbers of people who were designated, which has created a sense of panic in the judiciary. And as far as the numbers are concerned, I would say the more there are, the more welcome they are. Right. And you notice a really interesting change. I notice a very interesting change in people who are designated, one day before designation and one day after designation. I think what designation does to people is it also enables them to improve their own standards of advocacy. It gives them a sense of confidence. It also makes them far more responsible as lawyers, being officers of the court. Right. You do consider yourself an officer of the court when you're designated. So I, for one, have never had any complaints about the facts that large numbers are being designated. All right, if there are a large number designated, there will be some who are better than others, but that's the name of the game. You have to take it as it comes. And in the ultimate analysis, there is a legal market out there which really regulates whether a particular person is going to get briefed or not going to get briefed. So why is everybody so worried about the numbers? I don't get it. If you're not a good lawyer, nobody's going to brief you. If you are a good lawyer, you will get briefed.
Right. You have previously expressed concerns about the lobbying process that happens or influences the designation process. What measures would you recommend to ensure transparency and fairness, particularly with respect to lobbying?
Yes. See, one of the things that I made clear while arguing, and I'm very glad that it's been recorded and I think made part of the law of the land, sitting judges were giving recommendations to individual lawyers, recommending them for designation. That is the highest form of lobbying. And that I was very keen that should be stopped. Now, apart from that, lobbying is a fact. And I was a bit surprised that the learned Solicitor General, Mr. Tushar Mehta, actually agreed with me when I said that lobbying goes on. I don't know his reasons, but I know my reasons for saying it goes on. Particularly in cities like Delhi and the Supreme Court, in the whole capital territory of Delhi, which is heavily influenced by, I would say, politics. I think lobbying, sycophancy, and partying, and striking individual relationships with judges of practicing lawyers is very common. The other thing that I find very disturbing, of course, is that the kith and kin of sitting judges, you'll find them practicing all over every court. Right. And just by their look and feel, you can tell that, this is a person who is well connected with the judiciary. And all this has to change. You can't just change the method of designation and hope that the system will change, become more democratic. And in that sense, what I tried to do was just a drop in the ocean. There are many other systemic changes that need to take place. Now, at least, they've decided, the collegium has decided to put on record people who are related to each other within the judiciary. Okay. But we need to go a step further and put on record who are the children of judges who are practicing, with whom, in whose chambers, and where. Exactly. I mean, you have kith and kin of judges practicing in the chambers of law officers, okay? And those law officers are appearing before the Supreme Court day in and day out of their lives. So how can you claim that your system of administration of justice is, I don't know the right word for it, whether it's fair. I would say this is an unethical practice.
So even now, kith and kin of Supreme Court judges are practicing in law officers' chambers?
I'm sure about it. Yes, I think so.
The judgment calls for more senior designations of lawyers practicing in trial courts and tribunals. How will that work in practice? This particular direction has been hailed by all sectors of the country. So how do you think this entire process of trial court designations work?
See, while I agree that there are very good trial court lawyers, I don't want to sound patronizing, but I can tell you that I started my practice in a trial court. I started in the labor courts, and I actually believe that if you work your way up from the bottom to the top, you are going to be a better lawyer than any other lawyer. So, in principle, I agree. But the big question is, how do you identify these people? I don't think you can have any certification by any authority for that. It doesn't make sense. It's contrary to what the judgment is otherwise saying. But I know that very many trial court lawyers practice in the high courts, and I'm aware that high court judges will definitely know who is a good trial court lawyer. So I would expect trial court lawyers to be designated by high courts. I think that is a welcome change.
Do you believe that the court's recommendations will lead to substantive changes in senior designations process and inclusivity in senior designations process per se?
Under this dispensation, it'll be the reverse. And if we're back, we really are back to a system of patronage. You say that you have put criteria in place, even if we assume for a moment that the criteria are objective, the evaluation is purely subjective, because you've done away with the marking system. And I don't understand what kind of allergy judges have to academic pursuits, because I think a lawyer who follows an academic pursuit in addition to the practice of law makes a much better lawyer. And that was the intention of putting in the 100-point index a certain minimum amount of points for publications and articles. And by the way, you know that I'm a great believer in encouraging legal journalism. You know that because I have founded quite a few legal journals. One of them, of course, was The Lawyers, which was a print edition way back in 1985, and the first legal magazine of its kind. And now, of course, The Leaflet, which is a digital web portal for doing opinions. I encourage people, especially young lawyers, to always reflect on judgments of the Supreme Court. I do not think you can be a good lawyer just by quoting precedents. I believe that your ability of a lawyer can be told if you can critique a judgment of the Supreme Court and tell me how you would have written it in a different way, or what you think of it, and if you agree and disagree, why do you agree, why do you disagree? Now, all this has to be given a lot of weightage when you are designating a senior, the ability to rise above the pedantic pursuit of law. Similarly, pro bono work. I'm of course glad that there is no income criteria in the matter of designation. There used to be at one point. So to come back to your question, if you look at my original petition in a very kind of graphic way, and I had said that the existing system of designating is like a beauty parade. Beauty lies in the eyes of the beholder. What are you going to do? Are you going to just designate somebody because you think this person is good or not good? In that case, you might as well have a jury and a beauty contest and decide who you want to designate. And which is why it's very important that people, especially those who come from scheduled caste, scheduled tribe, from marginalized communities, look at the number of women who have been designated. I'm very proud that the number of women designated has gone up. You pointed out I was the first in my, in the category of women to be designated by the Bombay High Court. The Bombay High Court still has a very low number of women designated. But fortunately, the Supreme Court now has quite a few women who are designated. So this bringing into the profession the voices of the marginalized, whether they are scheduled caste, whether they are scheduled tribe, whether they're OBC, whether they're women, whether they're transgender. It's very important. And I would like to tell you why it's important. It's also important because the communities they come from are more comfortable talking to a lawyer from their own community. हमदर्दी होती है, एक तरह की हमदर्दी होती है, अपना लगता है. So that diversity has to be brought into the legal profession. You need to encourage first generation lawyers, you know. Sometimes I get absolutely sick when I hear these things. Oh, you know, so and so is from Harvard, and so is from Cambridge, and so is from Oxford. And what does that tell you about anything or anyone? Why can't you take pride in your own systems and your own work?
Absolutely, especially when it is to do with law that you will practice.
Yes, it's to do with law. It's to do with the rule of law. It's to do with the independence of the legal profession, independence from the judiciary. You know, there is this rather unacceptable process of sycophancy at the bar as well, you know, where they are willing to, go out of their way not to offend a judge. Now, I don't believe in offending judges, but there's a way of respectfully saying that you disagree.
Right. You just said a few moments back that a review is not out of question. In that particular light, what further reforms do you envision in the senior advocates designation process? Suppose, just assuming that this Jitendra Kalla judgment did not exist, even with the prior regime in place, the Indira Jaising judgment in place, what further reforms would you have envisioned with the change of time in the senior designation process?
I think we need to have a proper system of court management of time. I think seniors get disproportionate amount of time to address the court, which not everybody gets, and I think there's a great need to regulate that. I think there's just a handful of seniors who dominate the court, and that needs to change. If you want a well-read, well-educated, well-informed bar, that needs to change as well. You have to bring in new talent into the bar. I think seniors have a duty to mentor juniors. I think a senior's success needs to be measured by the number of juniors they mentor, the quality of the juniors they mentor, and obviously I think there also needs to be some system where juniors are getting paid by seniors. There used to be a system that a senior cannot appear without a junior, and that the junior has to be paid a certain percentage of fee. And none of those rules are being followed. And by the way, all these rules have a logic to them. And the logic is that you will have a well-informed, good bar. And there will be a proper line of succession of talent at the bar, which will help the judiciary. The jurisprudence of the court will improve.
But if I may ask, and if I'm being so audacious, does the chamber of Ms. Jaising follow this particular rule?
Yes, I'm quite proud of my track record, in the sense that I try not to employ any junior or have a junior without ensuring they get paid, without making efforts that they also progress. And many of my juniors have done well for themselves. Yes, I'm proud. Oh, and by the way, the other thing is, of course, ensuring financial probity. You can ask any one of my juniors. The first thing I tell them when they enter the office, no one will accept cash in. No junior of mine will accept fees by cash. Every single piece of work you do will be billed for, and you will receive your payments either by check or by direct as cash. You can ask them. I have no problem. Do an audit.
Okay. Ma'am, what specific measures can be implemented to dismantle the old boys club mentality and ensure equal opportunities for all deserving candidates?
I'm sorry, I didn't get the question. You said what measures?
What specific measures can be implemented to dismantle the old boys club, which is very famously called a mentality, and ensure equal opportunities for all deserving candidates?
Some of them I've already mentioned. I mean, I, some are already in progress. Like you should see, by the way, the interns who come to our offices or anybody's office. I meet a lot of interns who come from many offices, and they do very well. Internship programs help a lot in shaping. In fact, I myself I told you at once, I said it, I was thrown out of law school for want of attendance. Most of my learning I have done outside the law school. So I would say the same thing, that the specific measures should be that learning happens outside the classroom. Okay, that's one thing I would like to say. I have also tried to fund organizations which do legal aid, and there should be some amount of mandatory legal aid practice that a lawyer should do before they venture out to do a practice of their own. All the legal aid authorities in the country and the National Legal Services Authority must encourage young lawyers, and by the way, pay them well. They are very well funded. There's no lack of money, by the way, for any of these authorities. Go look at their budgets, and they should employ good lawyers. So just employ lawyers and ask them to do legal aid. Right. And that legal aid can be guided by a senior. Of course, you can't have a third-rate legal aid being given to a litigant, okay? Right. You have to make sure that they're properly supervised, but I can assure you that a lot of interns who have come into my office have done super work for me during their tenure as a student. I have a lot of appreciation for their work. So these are some of the steps that you can take. These are the people who will go on to become good lawyers. The second thing, by the way, it's very clear, the second thing that I wanted done and I succeeded in doing is to make sure that the proceedings of courts are live streamed. This is so that as a law student, you can start watching what goes on inside a courtroom. I have sat in a courtroom in my younger days and watched great lawyers argue. I've learned a lot from them. I've said that earlier as well. So when I decided to file a petition for live streaming of court proceedings, these were the issues that were on my mind. Accountability of the judiciary plus the educational pedagogic value of being able to watch court proceedings in real time. So it's so many things. And the other thing that I did, of course, was to file a petition making sure that the Supreme Court of India had a creche. There was no creche in the Supreme Court of India. What does it do? It enables women lawyers to bring their children to court and continue and not drop out of the legal profession. And I was very happy to note that fathers were bringing their children to court. Advocates were bringing their their children to court, and a couple of times when I asked them, well, where's the mother? I was told, well, the mother works in the corporate sector where there is no creche. So there are so many things you can do to democratize the system, to improve it. There's no one solution to the problem, but there has to be a desire to improve the legal profession. Absent a desire, you do nothing. You take a step backward. I find it a bit sad. I find at the present moment the Supreme Court is at a low in many senses of the word. Judgments are not properly, arguments in a judgment are not necessarily very elevating to read. Sometimes you find a judgment which doesn't even refer to the precedents of the court on the same issue. And it's sad. Why is this happening? Instead of being a forward movement, it seems to be a backward movement. And then there is, the looming question over our heads of independence of the judiciary from the executive. it's very sad to see that the recommendations of the collegium are not being implemented by the executive, and the judiciary is helpless. So, when you ask me, sometimes I feel, yes, senior designation, what is it? It's a drop in the ocean. It's just one small step in a very long journey, which I think will continue.
Right, and that was quite a profound statement that the Supreme Court is going through a low phase, and we can only wish for the phase to pass by.
Yes, because I mean, one of the biggest factors before the Supreme Court is when there is a dominant executive in front of you, when there is hyper-nationalism all around you. How are you going to keep your independence from the executive? That's all the judiciary is required for. We don't need a judiciary for any other reason. We come to the judiciary to seek protection against an overbearing executive. And if we don't get it, what is the point of having senior counsel, junior counsel, a whole legal profession, a whole judiciary, for what?
Right. And that brings me to my final question, Ms. Jaising. You have earlier taken a stand against senior advocates using different types of gowns. The Supreme Court has now left this aspect to the High Courts. Why do you think senior counsel should not wear different gowns? Isn't it a mark of differentiation in the court?
Yes. See, discrimination is always recognized by external signs. So, for example, the color of your skin tells you your caste. It's something that you get at birth, okay? The fact that you're a woman tells you that you belong to a particular sex, and given the misogyny and patriarchy that you see all around you, you can expect a certain amount of discrimination. In that sense, the difference in the gown is, in practical terms, is the real thing that distinguishes a senior counsel from a non-senior counsel. Now, if you look at the Advocates Act, what does it entitle you to do when you're a senior advocate? Your name is carried on a different role of advocates, which is the role of senior advocates. It doesn't tell you that you start wearing a different gown. And I checked the Bar Council rules for uniform. There is no prescribed uniform for a senior which is separate from the uniform of any other advocate. And that is the reason why I feel that if all advocates wear the same gown, you're halfway to ending discrimination based on senior junior. And I'm very happy that Justice Oka has recorded that in his judgment, but I do regret the fact that he's left it to the High Courts. It's not even the domain of the High Courts to prescribe uniform. It is the Bar Council of India. And I have on several occasions appealed to the Bar Council of India to ensure that there is a uniform gown for all lawyers. It will help a lot.
So that indeed says that there are going to be quite a few grounds in your review petition.
I don't know, no comments, but I can tell you that what I will say is this judgment undermines, we talk about undermining basic structures of the Constitution. This judgment undermines the basic structure of Indira Jaising 1. It is not something which is done to tweak the system or to improve the marking system. I could have very well understood if the marks were distributed. One very important issue that I think you need to take note of, the judge has obviously said that integrity and honesty are to be judged. But my question is, how will you judge integrity and honesty? Will you go by rumors? Integrity and honesty also require documentation to be judged by. It requires an FIR somewhere. It requires a pending proceeding for misconduct before a bar council. And there also you need to be very careful. Some kind of political rival might file an FIR against you or might file a case of misconduct against you. You can't take that as the basis alone for it without further investigation. So I'm really worried about this particular issue. Although I certainly believe that integrity, absence of integrity disentitles you to get a gown. But as I told you, there are so many other ways of dealing with it. Why is the judiciary not stopping the sharp practices which exist in the legal profession? That's one way to deal with the question of honesty. You have lawyers who know there's a precedent against them and they will not cite it. Isn't that a sharp practice? There are so many ways of telling whether a lawyer is behaving ethically or unethically. The joke, of course, is that Rishi Malhotra, with allegations against him, got designated by the full court. So I think the judiciary has a lot to answer for.
So that was Senior Advocate Indira Jaising with us, who has clearly told everyone that the recent judgment by the Supreme Court of India on the senior designations process has actually taken us 10 steps backward. Thank you so much, ma'am, for being with Bharat Bench. It was a pleasure having you with us.
I would like to put on record my appreciation for Bharat Bench. I don't know if you remember, but this whole process started with a survey which was done by Bharat Bench among lawyers as to what do they think of the issue of senior designation even before the petition was filed. So thank you very much.
Thank you, ma'am. Thank you so much.